the word draconian comes from Draco, who was an ancient Athenian lawmaker who implemented a code where everybody got the death penalty for the stealing of a cabbage on up. And his argument was, well, the problem is you should get death for stealing a cabbage. Just because we can't give you a worse punishment for committing homicide doesn't mean that you don't deserve it for stealing the cabbage.
From the very moment a defendant is involved in this system, someone else has control over their story. They want to define that person solely by the crime they may have committed. You have a sentencing date set, and the stakes are high. Both lawyer and client need to do everything in their power to prepare. But the question is, are you ready? I'm Doug Passon. I'm a 25-year defense lawyer, a sentencing consultant, and an award-winning documentary filmmaker. In Set for Sentencing, I'm going across disciplines and outside the box to help both lawyer and client expand their perspective, build on their skills, and get real results in the form of significantly reduced sentences. All of this in service to one goal: to bring more fairness, more compassion, and more justice to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, it's Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. With us today to help us get set for sentencing is the magnificent, brilliant, undeniably handsome Robert McWhirter, an attorney extraordinaire, an author, a speaker, and most importantly, a good friend of mine. So before we jump in, let me give you the scoop on Bob McWhirter. Like most of my guests, his resume is too long to do adequate justice to, but I will say this: Mr. McWhirter is primarily a criminal defense lawyer. I served with him as a federal defender for many years here in Arizona, but now he's in private practice. He has his own firm, and he's been in private practice for some time, a very long time now. And he is a certified specialist in criminal law, and with the State Bar of Arizona. So he is a prolific writer. And Bob has published several books, including a really amazing book called Bills, Quills, and Stills: The History of the Bill of Rights. And he's done the Criminal Lawyer's Guide to Immigration. He's published at least 40 or more articles in English and Spanish. Oh, did I mention he's bilingual? On the history of Bill of Rights, immigration law, criminal law. A really cool fun fact that I am going to, because my wife says, Doug, it's not all about you, but it is always about me. So I'm going to get to bring myself into this little tidbit on your bio. But in 2010 to 2011, Mr. McWhirter served in El Salvador, administering an $11 million U.S. aid project to reform the justice system there. And what he did is he developed and oversaw programs and trainings for the Salvadoran courts, police, and prosecutors. I imagine that must have been very interesting. But anyway, the list goes on. He's also a 2019 Distinguished Alumni Award recipient from his alma mater, the Sandra Day O'Connor College of Law at Arizona State University here in Arizona. This is the one that pisses me off the most, because I don't even know if my law school has a Distinguished Alumni Award, but if it does, I certainly know that I've never received it. So hats off to you, Bob McWhirter. Thank you so much for joining me. Oh, the last thing is the book you're working on, which I could, I suppose, plug at the end, but I'm kind of excited about it. It's the next in his constitutional writings, and it's called Fixing the Framers' Failure. And it's really a history of the Civil War amendments and how the framers of the Constitution had big ideas, inspiring ideas, noble ideas, but they didn't actually hit, maybe your argument is we didn't necessarily hit the mark with what made it into the Constitution.
Yeah.
So
Yeah.
we have a lot to talk. We have a lot to talk about today. So first of all, thank you. Welcome, welcome. Thank you for being here.
My great pleasure. Thanks for the introduction.
Absolutely. Did I do you justice?
Oh, you did great.
So I'm going to jump in. So your constitutional work is so exciting to me. This is how I bring myself into the story. Ready? So you may not remember this, but you were, I think, in 2010 when you were in El Salvador, you were also simultaneously working on bills, quills, and stills.
Yes.
And here's what I love about those books, aside from the fact that they're great primers on the Bill of Rights and the Constitution, which is, and they're not just for lawyers, they're for anybody. But this is what I love about them. They're chock filled with amazing visuals. So it's almost like, the illustrated history of the Constitution in a lot of ways. It's a book, but there's just so many amazing pictures that help tell the story of the Bill of Rights and these various amendments to the Constitution. So do you know the story I'm going to tell? Do you remember what this is about?
Not sure.
Okay,
Let's
I'm
start
gonna
with it. Yeah.
I'm gonna give you a hint. It has to do with the Second Amendment.
Mm-hmm.
Not ringing a bell yet. All right. So okay, the Cartridge family. Now are we getting somewhere?
Oh, yeah. Yeah. Oh, yeah. Yeah. Now I remember.
So Bob knows from practicing with me in my old office, I had a whole like Simpsons museum in there. So he knew I was a diehard Simpsons fan. He was writing the Second Amendment, and he was making reference to an episode of The Simpsons called The Cartridge Family, where they all got guns. And he wanted to include an image from the episode, but
I'll tell you what the problem I had there was. See, I believe in visuals, but there's these little things called copyright laws.
they're so pesky.
So pesky, even on The Simpsons, which are pretty, iconoclastic, but they still have copyright issues. But my friend Doug had in his office all the little figurines of The Simpsons. And of course, I could take a picture of those, and I own copyright in those pictures. So Doug loaned me his little figurines, and those pictures of those figurines, one of was Homer with pistols and no clothes on except for his underwear, ended up in the book as one of the examples from the Cartridge Family episode, where Homer has this great dialogue where he says, "No, Lisa, I need a gun because if I didn't have a gun, otherwise the King of England would come right in here and take it away." So.
Yeah, so I had a great time doing a photo shoot of Homer in his underwear, and emailed those photos down there. Flash forward to whenever the book came out, and I get a copy, and I flip to the page and see I want to see, and I learned that I got a photo credit in Bob's book, but there was a small misspelling in my name, and apparently it says Dung, D-U-N-G, Dung Passon.
Yeah, and somehow you embrace that.
I do. I feel like that's just embodies my essence.
Yep.
But anyway, the idea about visuals, there it is. It's
There's
a little
a-
blurry, and it's turned around, but we can
Yeah.
I'll put a picture up there. Anyway,
no.
but it's visuals. Why one of the things that I love about you and why I think you're such a good lawyer is because of this idea that you have so internalized the power of visuals, and not just in your books, but in the way that you practice. And I just want you to maybe that's just where we start. Why do visuals matter to you in your practice? How do you use that?
Well, I think every effective speaker actually shows more than the speaker tells. Now, of course, if you have PowerPoint, you actually can show physical images. But if you look at everything we learned about a theory of the case, when you think about most theories of the case, you're showing things. You're not telling things. I'll give you an example. I had a case where a young man was arrested early in the morning for the death of his child, and they took him in his pajamas and never let him out, essentially, got statements from him, etc. You could talk about that and you could say, oh boy, gee, wasn't that terrible? Or you could say, on this date, Johnny woke up to a nightmare that he's still living. Okay, now that shows something. We know what it's like to wake up to a nightmare. Okay, you're showing it. You're not talking about some factoid or something like that. You're kind of showing, you're showing humanity. If you think about everything with the hero's journey, you're using metaphor to show things. That's what the articulation of the hero's journey, which you've worked so well into your work, you're showing something that's universal in your client's story. And to the extent that you can do that in every statement in the court, and let's face it, you're not going to do it consciously all the time, and there's not always every opportunity to do it, but every sentencing, every jury argument, etc., it's what you show that matters, not what you tell or what you say. And of course, if you can use a tool like PowerPoint and actually use images, that really helps. But show, don't tell.
Right. Like, and in your example, if you had a booking photo that he's in his pajamas, or, you know, sometime body cam footage of somebody let out of their house in the morning in handcuffs and pajamas, you know, the idea is to put us on that hero's journey. So whatever your client's going through, you know, story puts us in that moment in time, and we see the world through their eyes. Now, for sentencing, I think this is so powerful. And, you know, there's this idea in telling a client's story of the power of the singular moment, which is something that sticks with you. So it's so powerful. Could be a waking up to a nightmare, that theme, you know, the words, but it could be one image. And whenever I can, I try to think of my cases visually, and is there going to be one picture that I could rely on? Because, you know, I make videos, but they're not for every case. So, you know, if I'm handling, you know, 100 cases, I'm only making videos in a small handful. But that doesn't mean you can't still do the tiny little movie in the form of one frame, a still photo, and have that blown up. You could do PowerPoint, have it blown up, or anything else. And I'll give you an example. In one case, my client was a concert-level cellist for the symphony. She met a con man who robbed her of her fortune and abused her and stripped her of her identity, sold her cello for pennies on the dollar, made her quit her job, manipulated her into committing fraud. So she's charged with fraud. And then she gets charged, and while she's waiting for sentencing, she divorces this guy, and she hasn't played her cello in years, but she got a cheap little student practice cello, and she started playing again. So that one image of a cello, you know, I might bring that cello into court, but that one image there told the beginning, middle, and end of her story, where she came from. You know, what a good, wholesome, talented, amazing person she was. And that was her identity. The middle is she's robbed of her identity and turned into something she's not, and did things she'd never do. And the symbol of that was her music is taken from her cello. And then Act 3, she's playing again, which means she's coming back to herself, right? She's returning to her best, most genuine, who she really is. So a judge, you're not gonna have to worry about her anymore. She's gonna be okay. She's not gonna be back here. And so one image, one picture, tells the entire story of the whole case. So that's awesome. I say images all the way, and that's a concept we haven't all embraced yet fully, but we should. Even in pleadings, putting pictures in pleadings, do it all the time.
Well, and when you think about the training we got about developing a theory of the case, aren't you really just developing the best image?
Well, I think you're developing the story, and then you're picking the best image, that one thing that tells that whole story. Yeah.
Well, let's play with metaphor. When we want to pick that story, what are we saying? We're putting our client in the best light.
Yeah.
Okay, that is evocative of image.
Yeah.
The metaphors we're using to talk about advocacy are really just about creating image. Let's put our client in the best light. Let's show our client to be the best person possible. Let's show the other side of the story. Let's do all these other things. And it's evocative of image.
Absolutely. Absolutely. And that is the biggest problem, I think, the biggest challenge we face. Not just images, but the idea that we don't show the truth of the story. We lawyers, we just rattle off like bullet points, which is telling. That's telling, not showing.
Right. Well, you just said something there that I thought was really good. You just said the truth of the story. You know, which truth?
Uh-oh, here we go. Let's go. Let's go. All right, which truth?
Well, the thing is, look, if you want it to be a simple telling, the most simple telling of all is what's called an indictment.
Mm-hmm.
There's nothing there. And if you look at prosecutorial methodology, it entails going through elements of a crime and it's giving a list and it's saying, here's this, here's this. Now, there are very effective prosecutors who branch beyond that. But the basic prosecutorial school is, here's element number one, here's this, and here's this, and here's the fact that shows Johnny did it, Johnny did this, Johnny, okay. That's just all telling.
Mm-hmm.
That is a certain truth.
Yeah.
But if you want to go about the truth, what do we usually do? We're looking for the drama.
Yeah.
Okay, yeah, Johnny did this, but after this guy, when Johnny walked home and saw his wife in bed with another man, that's a truth.
Mm-hmm.
Okay.
Yeah. Yeah. Deeper
That's
truth.
showing something. We could just say, oh, gee, he had, we negate the mental intent because he had a, temporary insanity, blah, blah, blah. Oh, that just sucks.
Mm-hmm.
What we want to do is talk about when he was there and he saw his life flash before his eyes.
So it's like it's so interesting because it's layers of truth, and people would say, well, what we do is somehow disingenuous, or it's false, or it's fiction. But that indictment, it may be true. Those legal elements may have been satisfied, and he may have actually committed the crime. So that is a truth, but it is a surface level truth. What's the story behind the story? And that's where these layers and nuances. Now, somebody who's not familiar with the system goes, sounds like a bunch of excuses to me. Let me put out my world's smallest violin and cry because he had a bad childhood. That's not it. It's these fundamental truths that we tell through story that don't excuse the behavior at sentencing, but they certainly give it context.
Yeah.
It puts it in perspective.
Right.
Because the government story is simple in another way, Bob. It's your client is terrible and needs to be locked away for as long as possible, period.
Mm-hmm.
I mean, that's the story in virtually every case. And it starts with the indictment and what they decide to charge, all the mandatory minimums, carries through to plea negotiations and what they decide in their gracious wisdom to offer you, and then it ends at sentencing. And it's the hero's journey in a sad state, which is we're the heroes. We've gone through trials and tribulations and persevered to conviction. Now all that's left, Judge, is to slay this dragon and save the kingdom.
Right.
And there it is. And so we have a very difficult time doing that, telling our stories. But if it's done,
yeah. Oh, I was just going to say, look, let's not forget that cynical thing about, our job is to obfuscate things. No, that is not true at all. The point of it is there are truths presented, and they're presented to two entities, and they're both called the same thing. They're presented to juries and judges. And what are they called? They are called fact finders.
Mm-hmm.
Truth is not established until the fact finder does it, which means the government just doesn't get to come up with an algebraic formula to make the result in this case, despite the guidelines' best efforts to create that system. There still is the role for the fact finder, which means truth is not established because it's a human process.
Mm-hmm.
And if you want to start dictating truth, just go live in the dictatorship.
Right. Speaking of which, I was looking back on the video that we made together where we were talking about Donald Trump and the Bill of Rights. Do you remember this? And I was trying to find the date because you were talking about impeachment, you were talking about all this, and it was just 2017. Like, it was at the very front end of him. And my God, who would have ever predicted? I mean, we certainly predicted there'd be a mess, but I don't know that anybody would have ever predicted this. But it just because this is a good segue into some constitutional issues, which I'm told you know a little something about. I'm going to play the tiniest snippet from this video, and the visuals are the key here, like all your work, but the audio will will be fun too.
For those of you who know this, I'm sorry to just kind of fall back in high school civics.
By gum, I'll stand on my constitutional rights.
But let's go to the basic. Article 1 of the Constitution is about Congress and the legislative branch.
We're proud of our country. We respect our flag.
Well, let's not talk about Donald J. Trump and burning flags and punishing people with loss of citizenship. If you're a president that doesn't particularly like the law, you do not have the freedom to ignore it or defund it. It is the Congress who decides what is the law, and the president must take care to faithfully execute that law. Now, if you give an example, let's say environmental, let's say there's a spotted toad. I don't know if there exists a spotted toad, but let's say that Congress passes a law that says we're going to protect the spotted toad, and the president comes in and says, I hate the spotted toad, we're getting rid of the spotted toad, we're not going to protect it. The president in that situation is acting illegally.
Donald J. Trump is calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what the hell is going on.
So there's just a little taste of what Robert McWhorter does with the Constitution. But so let's talk about sentencing. And what do you think in terms of the Bill of Rights, the amendments, what do you think are the most important ones when we talk about sentencing?
Well, of course, you've got the Eighth Amendment, which talks about cruel and unusual punishment. But the subtlety of the Eighth Amendment is it incorporates concepts of proportionality. And societies moved concepts of proportionality to get out of the blood feuds. And we kind of have to balance, okay, so you steal my wheelbarrow, I'm not allowed to go shoot you. And so we incorporate that. And as the state takes over the power of sentencing and police functions, well, we want proportionality in that too. Okay. The word Draconian comes from Draco, who was an ancient Athenian lawmaker who implemented a code where everybody got the death penalty for the stealing of a cabbage on up. And his argument was, well, the problem is you should get death for stealing a cabbage. Just because we can't give you a worse punishment for committing homicide doesn't mean that you don't deserve it for stealing the cabbage. Well, Draco was very popular in his day. And in the Athenian stage, he would go out and give a speech. And one of the things that you would do to a great presenter, if you like them, was throw your cloak on them, onto the stage and onto you. And Draco died because he was so popular with these crazy sentencing laws that he got suffocated by the weight of all the cloaks that were thrown on him. He was literally suffocated by his advocacy of the death penalty because it was utterly disproportionate. So the word draconian comes from Draco's code. And that's the lesson there, which is some of these things are awful popular, but they're not balanced, they're not right, and they're not what the Constitution provides in the prohibition of cruel and unusual punishment in the Eighth Amendment. Then you've got to get to this. Oh, go ahead. Yeah.
I love that story, and I did not know it.
Yeah.
And I think the opportunities for merch are endless, like coffee mugs that say "Screw Draco."
Draco.
I mean, honestly, you talk about this in this is what 1,000 years ago or something, but I think Draco's alive and well in our system, especially in the federal system.
Oh yeah.
But I also, it's interesting. Like, what does it take to get something deemed cruel and unusual punishment under the Eighth Amendment? Because I think tons of shit we're doing in our system is cruel and unusual.
Yes.
I don't remember the last time I've heard an argument like that made, and a winning argument for that.
Well,
tell me some things that have been cruel and unusual.
Well, the answer to what it takes is a better Supreme Court that has a better sense of history and proportionality.
And humanity.
And in fact, if you look at the original intent of the framers, was they wanted there to be an evolving standard of decency. That the framers who passed the Eighth Amendment says that, in the future, we can do better. Representative Livermore from Massachusetts was one of the articulates who talked about this at the constitutional or the convention, the first Congress rather, that passed the Bill of Rights and the Eighth Amendment. So the evolving standard of decency standard is the model, and it says that we're always supposed to be better than they were, which of course thematically ties into my recent book, Fixing the Framers' Failure. In some
Nice.
ways, we're always fixing the framers' failure. And the Eighth Amendment is a perfect example of that. There will be evolving standards, better ways of dealing with things. Modern example, we now know that young people's brains aren't developed till 25 or 26 years old, not 18. It's taking the criminal justice system a long time to catch up to that, but it will do it. We used to never have battered woman syndrome defenses because they didn't fit into the category of traditional self-defense. And we didn't have it. Well, that is now recognized as the defense. So there is evolving standards, and we are very slowly getting better. But we always have to fight those urges of the Draconians who want to make cheap political points by saying they're tough on crime. And by the way, if you need any other example of that, look what's going on with the Supreme Court nomination hearing.
Oh, I was just thinking that. Absolutely.
Yeah. Absurd.
Lindsey Graham was talking about punishment for child pornography, and Judge Brown was explaining how those guidelines were pre-computers, where somebody would have to order this through the mail, and the more they did it, the more egregious the offense was, and that's why the guidelines would increase. But in this day and age, with one click, you can automatically get 10,000 images, and that you shouldn't be held to that same baseline standard for number of images. And she said, she goes, you could do it with one click and end up facing 30, 40, or 50 years in prison. And she's absolutely right, because that's what the sentencing guidelines say. And Lindsey Graham got giddy about it, and he went, good, you should go to prison for 50 years for that. And I was like, oh, wow.
Lindsay. Yeah, but see, that's just a total loss thing. And by the way, you have to mention what's going on there is this trope and the association of Black people with criminality. I mean, I find it very telling that is the only thing they feel like they can get her on. They can't get her on her credentials. They can't get her on her brains. They can't get her on dignity. They can't get her on experience. So they're creating and tapping into this trope of criminality and African Americans. And
I wholly agree. But there's another trope that they're tapping into with that line of inquiry, and it's the QAnon thing, which is there are millions and millions of people who believe there's a giant conspiracy of pedophilia and killing babies and drinking their blood and sex trafficking of children. And that it goes through the highest ranks of government and Hollywood and everything else, this cabal of pedophiles. And by sitting someone down in that chair and saying, you love pedophiles, you're soft on pedophiles, because they kept equating child porn with pedophilia, which is two different things. But they're playing into this base, and guess what? Someone's going to get fucking killed if they keep doing that. Because as far as those folks know, they just put a baby-eating pedophile on the court.
Right. Not to mention the fact that it would probably be attacking your best pizza parlor, too.
Oh, yeah. Pizzagate, baby.
Baby.
Anyway.
Oh, it doesn't
So
stop.
the Eighth Amendment sucks. I like that because wasn't the death penalty at one point, maybe the electric chair was deemed cruel and unusual? And then, is that right or no? Well,
it was actually in a case called N. Ray Kimmler. It was actually upheld, but Kimmler had terrible facts. It was a terrible execution. It was a total botched thing. And Westinghouse, it was part of the war of the currents between Edison and Westinghouse. And Westinghouse funded the defense of Mr. Kimmler to try to stop that. And it was such a botched execution, and they had, smoking flesh in the room. It was terrible. His response was, they would have done better using an axe. So it was just horrible. But generally, methods of execution, the Supreme Court has not prevented. It has to be both cruel and unusual, not just cruel. And so that's kind of the problem. We're better off talking about evolving standards of decency.
Yeah.
And really, it's just, it's barbaric and it doesn't perpetuate a social good, having the death penalty around. So.
All right.
Yeah.
So
by the way, other amendments, you got to kick in the Sixth Amendment.
Yeah.
In any given time, the only lawyer the Constitution guarantees that you have, and that includes on the bench, by the way, is the defense attorney. The Constitution doesn't guarantee a prosecutor, doesn't guarantee you a judge who's a lawyer. It talks about judges in Article 3, but it doesn't guarantee you one. The only lawyer that's guaranteed to be in the courtroom under the United States Constitution is a defense lawyer. I kind of like to remind my prosecutor friends that I'm the only one here that the Constitution says needs to be here. The rest of you don't need to be here.
Yeah. And it's kind of ironic given that defense lawyers get so little respect in the system. But yes. And so let's stick on the Sixth Amendment, because one of those is right to counsel. My recollection is right to confront is part of the Sixth Amendment as well,
right?
Which means to be able to credibly, well, tell me what the right to confront means. You're the scholar.
Well, it has, one of the things about Antonin Scalia was every so often he did have some intellectual consistency. And that was related in Crawford versus Washington, which overturned an older case versus Ohio versus Robbins, which was, when I read that Ohio case in law school, I knew it was wrong. And it took decades later, but Antonin Scalia recognized it's wrong as well. What the Ohio versus Roberts case said was, your right to confrontation is commensurate with the boundaries of the hearsay rule. And Antonin Scalia said, no way, you have the right to confrontation at every meaningful proceeding, especially during trial. And the word confrontation comes from the Latin. Frente is the word for forehead. It literally means, if you go back to the Latin root, face to face. You have the right to face your accusers. And there's a lot of great stories in the common law, the trial of Sir Walter Raleigh, where, people afterward, like Edward Coke, the great jurist, came in and said, no, you have to have the right of confrontation. This is fundamental to face your accuser.
Okay, so the polar, I think the opposite of the face to face and the frente would be the hearsay, which is just stuff that's uttered out of court that comes in the form of papers, or someone said this about this, and you don't actually have a right to be face to face with the person who made the statement. But hearsay is everywhere at sentencing. It's allowed all over the place. Why?
Because they haven't extended the right to confrontation in sentencing, and they've tried to boil sentencing down to that algebraic formula that you and I have spent our life fighting against.
But Scalia said you have the right to confront at every meaningful proceeding. There's no more meaningful proceeding than a sentencing hearing.
Right. The trouble is they have all cheated, because they, on the one hand, maintain these rights of trial, and yet fail to recognize a system that has denigrated the right to trial to less than 1% of the cases that ever happen.
Yeah.
So
it's a sentencing system.
It's a cheat. It's a sleight of hand.
All right. Well, can we bridge Scalia's ruling there to Scalia's ruling in the Booker case? All right. So tell me, because this is how I think he gets around some of the cheat, which is the problem. We always start with the but. What's the problem? It's sentencing. The problem is there's all these ways that your sentence could be enhanced for things that people say about what you've done in the case that may have never been proved in any meaningful way, or even admitted to by the defendant in a plea agreement. So all this hearsay is coming in, and it's ratcheting up the time that you're spending in prison, because that's how the federal sentencing guidelines are structured. And so what happened? Take it from there.
Well, I think you can do things. Now, look, we make tactical decisions. Okay, so the hearsay comes in, but we also make a decision. Do we really want to challenge that? Do we really want to bring that witness in and have it even be worse for our client? A lot of times we just accept the hearsay as a tactical replacement for a victim walking on the witness stand during a sentencing and beginning to cry. So we do make our little tactical decisions when it comes to that. But on the other hand, we do have leeway to bring people in at sentencing.
Yeah.
And to challenge pre-sentence reports. And if we started blowing these up in the interest of the clients, unfortunately, we can't collectively bargain, right? But if we did start to blow these up in the right cases, you would affect change and start to make sentencing hearings a little bit more substantive and a little more like the trial that your client just waived his right away to have.
Some judges really don't want us bringing live witnesses into court, though. And in our district in Arizona, they're pretty good about it. And by and large, super fair, considerate people, and judges. But I go all over the country, so I've kind of seen the whole spectrum. And there are certain judges that say, I'm not hearing any witnesses.
Right.
Let them write a letter or something.
Yeah, and I think we can start challenging that and tap into the Booker and Apprendi line of cases. Say, look, if you're supposed to be a fact finder, you're supposed to hear all the facts.
Yeah.
And in the right cases, make those challenges.
Yeah. Yeah, you have to.
Right.
Because what they would take is a letter, which is such a dull, sterile way to communicate a story that what they're doing is they're, and I'm sure it's not malicious, but it's putting up these great walls of indifference and other, that you can't break through with a letter all the time. You need the human face.
I have found that it's sometimes hard to attack the other side's witnesses in a sentencing hearing because you're talking about people that can be evocative of grief and a bad narrative. However, I have found it fairly easy to put our own witnesses on. Now, maybe that's unique to the District of Arizona and in Arizona courts in general. But you can engineer and organize a compelling sentencing hearing. I recently had one in state court in Tucson, where we spent about 2.5 hours in that sentencing and put on numerous witnesses, which came quite well, did very well, and a good judge.
Yeah.
And so there are things we can do. My thought about this is, hey, yeah, it looks bad, but don't despair. Our job is not to despair. It's to keep going.
Hope is a good thing.
Hope is a good thing.
Bringing in witnesses goes right back to the beginning where you said show, don't tell. Because, I find even just having the people sitting in the back of the courtroom, even if they don't talk, it's a story you're telling.
Yep.
Visually. And by the way, again, to make this all about me, that's one of the main reasons we do sentencing mitigation videos. We may have 5 or 10 people that are super important to our client and the judge needs to see and kind of spend some time with, but that calling them as a live witness may not be feasible for whatever reason. Maybe they're going to be too nervous, or maybe they're going to be out of town, or maybe there's a pandemic, or whatever the case may be. So we weave them all together in a sentencing video, and actually the judges sometimes appreciate that because it's inevitably a more compact, more relevant proceeding, because we're getting right to the good stuff. You
can spend hours producing a 10-minute video, which would take you in court 4 or 5 hours to present that evidence once you get through all the garbage. And the number of times people have to be introduced, and please spell your name, and and all that little ritual that goes along with a sentencing hearing. You can compact it to a video. And because you taught me how to do several of those years ago with my little bank robber client.
That is right. I remember.
And it's effective because it condenses and allows you to present your story. I got to tell you, and this quite well, the artistic form of the 19th century was the novel. Of the 20th century and the first part of the 21st century, it is the movie. It is cinema. That is the narrative tool and device we use. And part of the value of that narrative is the way one shot can take place of what would normally be 20 pages of description.
Mm-hmm.
And the same thing holds with our clients.
Well, I could take that even one step further because I would argue that the movie became the TV show, became the YouTube video. Because if you look at the way people are consuming their content, the Oscars just happened, and I put on my Facebook, I see the theme of the Oscars tonight is movies. Remember us? ? Because they were going back in time, like this is The Godfather and Pulp Fiction, and I'm like, we used to make movies. Remember?
Right.
You should care about them, but the truth is, no one's going to the movies, and also our attention spans are getting smaller and smaller and smaller and smaller.
True.
And so sitting through God forbid 2-hour movie is just excruciating for me. First of all, movies shouldn't be that long unless you're the goddamn Godfather, and nothing is. Don't give me a 2-3 hour movie. And if it's a superhero movie, I'm going to end up killing someone by the end of it. But I digress. The point is, I don't even go to the movies. I like short form. I like TV shows. I want to sit with something no more than an hour and have a satisfying beginning, middle, and an end.
Sure.
And my kids, just to finish that
Go
thought,
ahead.
my kids aren't going to watch a TV show. They're into a 2-3 minute YouTube video that's got a
Interesting.
beginning. So see how it's going.
Well,
Sorry.
but there's a little subtlety there, though, Doc. With the TV show, you get your discrete hour. But one of the advantages, by the way, I don't watch television sometimes now, not because it's bad, but because it's too good. And I don't have the time to devote to it.
Yeah.
When I was growing up, you had Hill Street Blues, and that was about it for great TV, right?
Mm-hmm.
There are any given time 5 or 6 great shows you should be watching. But although they are discrete in an hour, there's a certain art form there because the story arcs go across multi-seasonal. And that is a different thing. So just take, for instance, Game of Thrones.
Mm-hmm.
Yeah, you get your hour. And by the way, I'm still mourning the Red Wedding, but you get your hour. But it is a multi-seasonal story arc, which does demand attention and is compelling. So it's not all doom and gloom in terms of the narrative form. And hopefully your kids, 5-minute videos tie into bigger narratives at some point.
Well, that's up for debate. It's certainly a bigger algorithm that YouTube is aware of and feeding them the same kind of thematic content. But, the other cool thing about TV along the lines of your multiple bigger story arc is that's what lawyers have to learn from TV shows. Because what we're doing is we have to find the overarching narrative to our case, but then we're telling these smaller episodic stories. And if you look at any good well-crafted season of television, there's usually a thematic arc to the whole season that the whole season is really about. The Wire is the best example of that because one season would be about the unions and one season would be about the press and one season would be about politics.
Right.
But it's all the same characters in the same kinds of storylines, but it's feeding this larger narrative arc. And so that's how we really should be approaching our trial stories and our sentencing stories. What's the big picture? And then start telling me smaller stories to put the pieces together.
Doug, I'd like to give you an example. I was thinking about that case you helped me make that video on. This had to have been 15, maybe 20 years ago. Young woman, nice young woman who got involved with her sister in a bank robbery.
Yeah.
Her sister was the teller who arranged to have a lot of cash at that branch. And my client, who was the sister, disguised in a trench coat and fedora, which I kind of had an affinity for, came in and pretended to rob the bank. The unfortunate thing is another teller showed up early to work, because if that other teller wouldn't have showed up early, it would have been bank larceny, not bank robbery, which has a lower penalty. Okay. Now, these poor little girls grew up in a house of unheard of abuse. The father was probably sexually abusing the older sister. Horrible, horrible men. Now you can talk about, they had a house of abuse, blah, blah, blah. The better way to talk about that was, Your Honor, when my client was 7 years old, she saw her father take her beloved cat and feed it to the dogs because he was angry at her. Now, do I really need to tell you all the abuse after that? And then it's an easier step to the compulsions that led my client to be in front of you today. Now, you can chronicle all the abuse ad nauseum, but that story worked better. And by the way, talk about truth. It was true.
Right.
It's bringing out the truth of these things. I think that would be an example of how to show something rather than just tell something.
Yeah. And you mentioned you basically use that to connect the dots to how they arrive at this horrible moment in time.
Right.
Yeah.
Right.
And that to me is the key where those stories should lead, because otherwise it's just a series of what I call pity points, which is which is getting at sympathy, which is poor me, feel bad for me,
Right.
and give me a break, and that's not the way we win at sentencing. It's not, sympathy, I say, is puts a wall up. It says, sucks to be you. I'm glad I'm not, and
Oh.
kind of look away.
There was
But
a judge in state court who actually would say on the record, I'm not here to give you sympathy.
Yeah.
And
And they're right. They're
I'm not
not.
here to show compassion. I'm not here to show you compassion.
That is not right.
No.
I would argue that that's exactly what they're there for. But
I
again,
agree.
But
But
I
there
think
was no hiding her sentimentality about that. She was clear. I am
Oh
not
my.
here to give you compassion. I'm here to apply the law.
I literally just got a sick feeling in my stomach to hear that there's a judge. I'm not surprised, but to hear them
Right.
say that. But yeah, and I agree. A judge. I don't think a judge is supposed to give sympathy, but I do believe a judge is supposed to give empathy. And so instead of saying "sucks to be you," you want them to be saying "that could be me," or "that could be my own kid," and I understand what happened here.
There is an old notion too, and unfortunately it's become an old notion, where the jury and the judge are supposed to be representatives of the community, which includes, in the right case, showing that compassion, showing a broader sense. People are not an algorithm, and they keep wanting to create algorithms for us to treat them that way.
Yeah, the federal sentencing guidelines being the worst example.
Yep.
Well, we're coming up on almost 50 minutes. I don't know how that happened, but we're having a lot of fun. I think I have a couple more questions for you, and then whatever else is on your mind. But the first one is, so you've been doing this longer than I have. I won't say how long, but I've been doing this over 25 years. And so I want you, if you could go back to your law school self with zero experience and just about to be thrown into this incredible world of criminal defense, what would be the advice you would give that kid?
That was interesting. I started practicing in 1988. The federal sentencing guidelines were passed in 1987. So literally, I had not known any federal sentencing that was not federal sentencing guidelines.
Mm-hmm.
So that was my entire world and experience. The good part about that is it allowed me as a young lawyer to tell my clients with a certain degree of certainty what their range was. Usually a lawyer would have had to develop a certain amount of experience to get a sense of this judge, et cetera. So that did allow that. I think what I would tell that person is just keep trying to think outside that box. And we didn't know at that time how much there was ability to think outside that box. This was before they had the lists of 88 easy departures, which are now called 88 easy variances. So keep thinking about pushing the way to get those departures and variances and all these different case law that developed around those things. Appeal to the judges who liked the old system where they had discretion to do what they thought was right. And that's probably in this context to do things. I would probably also tell myself is don't get so upset when certain supervisors in the office come down on you, because that's just them being jerky. So,
That's why we both work for ourselves now, I think, maybe.
Yeah. And like we don't have any ability to identify with some of our clients' oppositional defiant characteristics.
I think that's a perfect place to end, not the supervisor aspect, but the thinking outside the box aspect. I think that would be my advice too. It's like, the law is this old institution with all these formalities, and this is the way we do it. Well, it's not the way. It may be the way we do it, but that doesn't mean it has to be, because it ain't working. I have a friend and teacher. Her name's Liz Vardakessian. She's a scholar and runs the mitigation, whatever. But I saw a talk with her, and she came out of the gate saying, "Our system's not broken." And I said, "What?" I think it is a little bit. She goes, "It functions exactly the way it was designed to." Which is a lean-in moment, because
Right.
a systemic, the way our system was built. It was built wrong, is what she's saying. And her takeaway is it's our job to disrupt it. We have to be the agents for change, and the only way we do that is by thinking outside the box and trying new stuff.
Well, don't forget, I'll give you a great quote from the great Oliver Wendell Holmes Jr. Truly one of the great writers of the court, said, "There is nothing more revolting than saying we should follow a precept of law simply because it was that way in the time of Henry IV.
Mm-hmm.
Nothing more revolting than that. If that's your only argument for doing that, it's just revolting. So let's have a little bit of revolution."
Only other thing I found more revolting is Draco. It still left a bad taste in my mouth for that guy.
Just remember, he was suffocated by his own popularity.
I like to go back in time and punch him in the throat. Anyway, Robert McWhirter, thank you so much for this. If people need you or want to read your books or get you your legal services or whatever, what should they do?
Well, the books you can buy on Amazon. And to contact me, I believe you can still find me on the website or in the bar directory, or just type in my name.
Or visit the show notes for this particular episode, because I'll put links to your books and stuff like that in the show notes. But anyway, I'm sure I'll see you around for lunch. Thanks for doing this. All right. Great to see you. Thanks, Bob. Appreciate you. Bye. That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you like the podcast, please do me a favor. Spread the word about Set for Sentencing and give us a rating and review on the iTunes podcast platform. It would really help. Last but not least, if you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.